there are a lot of significant and developing issues with that relate to how you're treating your employees in all this that I'm thinking are falling by the wayside, except when you call me to say, can I please fire this employee for what they wrote on Facebook? And you know what? Before I even want to know what it says, I want to know how you got it. Do you know why? Because there's this really big and scary law out there called the Electronic Communication and Stored Communication Act that none of you are thinking about. Some of you might, because I see a few of you shaking your head. Maybe I've scared you before. But this is a law that was really enacted to stop the capture of electronic transfer of information en route that was really the intent was to stop law enforcement from intercepting electronic communication, but it applies to you. And if you are not an intended user or an intended recipient of an electronic communication, you have no right to obtain the electronic communication. So if you are not a friend on Facebook, or the person who got you the post that shows you how nasty you are as an employee, or an employer on that employee's Facebook page, you have violated this act and you're not even thinking about it. Then let's also get into, is it accurate, is it current, is it something that's appropriate to use for employee discipline? Then we'll talk about content. And when we are talking about all those bad things that employees are saying about you, and it's not happening as much as you're worried about, but it is happening, there's a huge growing area of law under the National Labor Relations Act. And you're all saying, we're not unionized, why do we care, right? I mean, I don't think there are a lot of unionized employers in here, but you know what? You are covered by the National Labor Relations Act. Almost all of you, I know there are a few people who are exempt, and we've got some public sector employers in here who don't have to worry about it, but overall, all employees, almost all employees, the labor relations specialists are in the back of the room, they'll pipe up if I misspeak or anything, but the National Labor Relations Act says that your employees, whether unionized or not, can engage in protected concerted activity for their mutual benefit. What does that mean? It means they can complain about terms and conditions of employment when they're acting together. And so when someone starts a blog, and there are a lot of MySpace cases out of this, which I know is an antiquated forum, whatever you want to call it, where they say, my boss is such a jerk, and then 5 other people chime in with examples, that is likely protected activity under the National Labor Relations Act. And our National Labor Relations Board is hot on the trail of your actions, and in fact, 2 days ago, issued a second report involving policies that are overbroad, that stifle employee concerted activity, employers inappropriately firing employees for protected activity, all based on social media activity. So I want you to be very mindful of this when you are calling employees to task for not doing what you wanted them to do. Don't forget about this bubble of the National Labor Relations Act. The other thing that you really should be thinking about is when we talk about attracting top talent, I know that you're also using it to do background checks, right? You don't have to admit it publicly, but I know that you are. I know that you are, and it's just like any other background that's out there. If you are using a third-party search engine, maybe to gather information, is that little Google search of social media use by your applicant also a background check covered by the Fair Credit Reporting Act? Maybe, it might be, and there's an opinion letter out there that says it might be. Are you getting relevant information? Are you getting accurate information? Are you getting current information? And also, I would like to know, are you getting information that you should not be using in determining the eligibility of that employee? You really don't want to know that they announced they're pregnant, they just finished a medical leave, or any other impermissible reason that impermissible reason for making a hiring decision. Once you know it, you cannot unknow it, right? You cannot erase it. And more than any other time in employee issues, you have created a footprint that their lawyer can follow right into. How is it that this was the top candidate until you saw the Facebook post that she was pregnant? You may have a lot of good reasons, but you have no credibility when you speak that out.